Good morning and welcome to my practice. I am attorney Patrycja Karlin from Chicago, and today we're going to hit the ground running on employment immigration. So today we're going to discuss EB3 employment visas that its process from the beginning to the end allows a person sponsored by an employer to become a green card holder. So today I will specifically address EB3 visas in the context of adjusting status in the United States. What does that mean? Well, we have a consular processing and we have adjustment of status for people who are eligible and live in the United States. So that same concept applies to family-based visas as well as employment visas. So what are EB3 visas? EB3 employment visas are visas designated for workers, skilled and unskilled, meaning people who at minimum have a high school degree. Those people are classified as unskilled workers, and people with a high school degree and at least 2 years of experience in a given profession are characterized as skilled workers. What is the difference? The difference is waiting time. Currently, unskilled workers under EB3 visa wait approximately 7 years from beginning to the end of the process. Skilled workers wait about approximately 5 years from the beginning to the end of the process. So people who can show 2 years of experience in a given profession can shave off 2 years of waiting time for a visa number. And what does the process look like? So the process is relatively straightforward. It's not simple by any means, but it's straightforward. First and foremost, we file for a prevailing wage with the Department of Labor. That process takes about 6 months right now. If you file an application for a prevailing wage, you can expect the results of that application 6 months later. What happens after that? After that, we advertise the job. We're required to advertise it in the state where the job is offered on a state employment website and in 2 publications, Sunday publications. Usually that happens in the Chicago Tribune, Chicago Sun-Times, that we publish that. That takes about a month. And then we have a 30-day waiting period after the advertisement runs out to allow people to apply for the job. So advertisement process takes 2 months. So we have 6 months for the prevailing wage, 2 months for advertisements. So that's 8 months. And then we can start working on the PERM certificate. Again, PERM certificate is filed with the Department of Labor. And right now, the waiting time for approval or denial of the PERM certificate takes about 1.5 years. It takes about 18 months. It used to take a lot shorter, but now it is approximately 18 months. The chance of denial of PERM certificate or approval of the same is about 50-50. So it's very important that the PERM certificate is filled out correctly in every field because the chance of denial is very high. And when the PERM is denied, they do not tell you what is wrong with the entire application. They tell you the first stumble. Whoever the reviewer was, he or she will tell you the first reason why the application is denied. So if there are other issues with the application, you won't know that because the first reason for denial will be that reason for denial. And they do not go into details what else could potentially be wrong with the application. So the PERM certificate process is fairly intricate. It's very detailed, and it requires really a skilled attorney to file one. So let's say everything goes well. Again, 6 months for the PWD, 2 months for advertisements, and now 1.5 years for PERM. So now we're at 2 years and approximately 2-3 months later that now the employer can file I-140, the petition that sponsors the employee for a green card. And that petition can be approved within a year, 1.5 years, but that doesn't mean that the worker can automatically apply for I-485, which is the green card application. The employee has to wait patiently in a queue until visa number becomes available for that employee. And as I mentioned, that period of time for skilled and unskilled workers differs in approximately 2-year block. So unskilled worker will now wait approximately 4 years for a visa number to be approved, and skilled worker will wait approximately 2 years for a visa number to be approved. And after the visa number becomes available, that's and only then can an employee file for a green card. So we're talking for unskilled workers, we're talking a period of approximately 7 years. For skilled workers, we're talking about a period of approximately 5 years from beginning to the end. And who can adjust status under EB3? Only employees who have been in this country legally through the entire process. So whenever employee calls me and says, hey, I would like EB3 visa, is that possible? My first question is, what is your current status in the United States? And for example, Ukrainian nationals can very easily apply because they're currently under TPS status. A lot of other nations are under TPS status, even though Trump is trying to cancel some of those, and eventually those probably will be canceled for some nationals. But people who are waiting, for example, for an asylum, they filed for asylum claims can take years to process. Those people are considered in a legal status, and those people could potentially be sponsored for an employment visa and can potentially adjust status under that category. People like yesterday, I had a call from someone who said my employment visa green card was denied. And I'm like, my first question was like, of course, why? And the lady said, because I'm an overstay. If you overstayed your visa and could not extend it or switch it to a different category, you want an overstay, you are currently in an invalid immigration status, and you will not be able to apply for an employment visa or a green card while in the United States. So another category of people who could apply for employment visa and keep their status current are students, are people who are on F1 visa. So if people can switch from a tourist visa to F1 visa or apply for asylum while they are on a tourist visa, or so those are, or qualify for a TPS status because they come from a specific country that allows them that qualification. Those are the people that are encouraged to apply for an employment visa. But again, the application for employment visa comes from the employer, not from the employee. So it's a goodwill of the employer who wants to sponsor someone. So even though a lot of people call me about employment visas, it's the employer that I want to talk to because I want to get a sense of whether the employer is committed, because it's a long time commitment. The employer has to be committed to the employee for the entire duration of the process. So, and there are employers who love their employees. They know it is very hard to find someone reliable for a specific job, and they're willing and able to sponsor their employees for a green card through the employment visa system. I know this is a lot of information, but if you have any questions, if you want to see whether this is something for you, please call my office. Obviously, as usual, my contact information is on the screen, and we can take it from there. Every person's situation is specific, is a little different, so I strongly encourage you to consult with a qualified attorney for that. Please like my video, subscribe, and call my office. I'll see you next time.